Welcome to Law, Life, and Liberty with Anthony Puopolo.
Welcome to Law, Life, and Liberty with Anthony Puopolo. Anthony G. Puopolo is a Massachusetts attorney who helps families navigate divorce, custody disputes, and criminal charges that often overlap. With offices in Lowell and North Andover, he represents clients across Middlesex, Essex, and Suffolk counties in both family and criminal courts. I'm Lisa Mosby, and today we're talking about how restraining orders can affect custody and parenting in Massachusetts. Welcome, Tony. Thanks again for joining me.
Thanks, Lisa.
Tony, in your practice, handling both family and criminal cases, how often do restraining orders end up becoming part of a divorce or custody dispute in Massachusetts?
Well, I would say based on what I do, my idea might be somewhat skewed if you asked a different lawyer who didn't tend to practice both criminal and divorce. But I would say restraining orders come up in, I would say, about 40 to 50% of my cases.
And when a restraining order is issued between parents, what usually happens right away with custody and parenting time?
Well, I think it largely depends on what court issues the restraining order. The first thing that'll happen is you'll get a temporary order. The person who is seeking the order will get a temporary order that lasts for about 10 days. If the children are on it, essentially all of your parenting rights are severed immediately until that next two-party hearing. If it's in the district court and the children are not included on the restraining order for the long term, for the extended order, you still technically have your parenting rights, but you have no real way to exercise them because you are not able to contact the other parent, unless you ask the judge to allow some kind of contact via some written means to facilitate parenting time. But if it's done in the family court, often the family court judge will also try to look at some kind of reasonable parenting plan until the parties are able to be heard on a temporary orders motion.
And Tony, in Massachusetts, does a restraining order automatically mean one parent loses the ability to see their child, or is that situation more complicated than that?
It is definitely more complicated. I think, again, like I said, it depends on if the children are not on the order, then it's just a question of how can communication be facilitated to allow for parenting time. If the children are on the order, then you have to go to the family court to modify it in some way to allow contact with the children if that court feels that contact with the children is in the child's best interest at that time, which will largely depend on, what were the facts and circumstances that led to the restraining order in the first place.
And you know where I'm going with this next one. What factors do judges look at when deciding whether parenting time should maybe continue to be supervised or be paused after a restraining order is issued?
So, Massachusetts General Law, Chapter 208, Section 31A, specifically instructs family court judges on what they should consider doing if there has been a serious incident of abuse or a pattern or history of abuse. Judges can they're required to find a way to ensure the safety and well-being of the child as well as the abused parent. They have to consider things like, should there be absolutely no contact? That's severe, but it would depend on the facts and circumstances. Can contact be facilitated by means of just a supervised pickup and drop-off, such as at a police station? Does the abusive parent need to be subjected to supervised visitation? The court's going to look at, was the child present during this history of abuse? Did the child witness it? Was the child completely uninvolved? Because the court's going to look at, if it's just between the two parents, that shouldn't inherently mean that you don't get to see your child. But the court is required to put guardrails in place to make sure that everyone is safe.
And then if someone is served with a restraining order and there are children involved, what are the most important things they should avoid doing during the early days of a case?
Well, it depends on if we're talking about the emergency ex parte order versus the 1-year extension. So with the emergency order, the person who's seeking the order will go into court. You won't be there, and they'll get an order that lasts for 10 days, at which point the first thing you should be doing is contacting a lawyer. Don't think that this is something that is not serious. It is very serious and will have life-altering consequences. Get an attorney who's experienced in handling this area of law. Prep for that hearing because it will really determine the next year or more of your life and your parenting time with your children. Don't try to contact the children. Even if they're not on the order, if they have their own phones, don't resist the urge to try to contact the children for anything other than just to say hello. Don't talk about the case. Absolutely do not talk about the other parent. After the order is issued, if it is issued for an extended period of time, if the children are still on the order, you should get into family court as soon as humanly possible to modify the order as the family court sees fit to allow for contact with your children.
And then how do temporary restraining orders issued on an emergency basis differ from what can happen once the case reaches the longer term hearing?
So the emergency order is generally issued for usually no more than 10 days. You're not there. You don't get to submit your side of the coin as far as the story is concerned. And at the full hearing, you will be there, hopefully with a lawyer, or if you are representing yourself, prepared for every curveball that could come at you. Don't delete text messages out of anger because those are evidence. You want to look at all of the things that might have ever been said in writing that could be twisted in a way to make it look like you're abusive, and make sure that you've got the entirety of that message history so that the full picture can be shown to the judge. I've very often seen messages where someone came in with a very truncated version of a conversation that looked horrible on its face, but when you looked at it in the context of the full conversation, it was not nearly as bad as the person tried to make it look. So being very prepared for that hearing is very important.
And then, Tony, if the restraining order is later dismissed or expires, how does that affect the custody arrangements that may have been put in place?
Well, so it generally doesn't. Now, that said, it's really more if I've seen some district court judges, even though they're really not supposed to do this, put a parenting plan in a restraining order. They don't generally have the authority to do that. That requires a family court judge. However, I have seen some judges say, mom or dad has parenting time every Saturday from 9 to 5. Now, if that's the only order we're talking about, if that restraining order expires, it goes away. But if it's orders that were issued by the family court, those are separate from the restraining order. So if the restraining order goes away, the benefit is now you're not necessarily as restricted in communications. But if the family court order said, for instance, you may only communicate via our family wizard, even though the restraining order is gone and using a text message versus our family wizard is now no longer criminal, it would still be contempt of court. So you still have to follow the orders.
And then, Tony, what kinds of evidence tend to matter most when a court is trying to decide whether parenting time is safe and appropriate in these situations?
Well, obviously, physical evidence is the most important thing. If there's, documentation of injuries, bruises, that's the most important thing. And obviously, in those kinds of severe violence situations, that weighs heavily in a judge's decision making. Is the Department of Children and Families involved because the child witnessed the violence? We know children should never witness violence. It will have life-altering consequences on them, and courts take that very seriously. If the child was not present, the child knows nothing about it, and it's able to, the pickups and drop-offs are able to be coordinated in a way that's safe, then there's still going to be a presumption that you should be able to see your child.
And we're talking a lot about physical evidence. You mentioned bruises and things. What about the mental health aspect of this? We've heard terms like gaslighting or other words on how somebody can be suppressed mentally or emotionally. Does that factor into these cases at all, or how do they research this or find evidence about that?
So they absolutely do. In terms of, Text messages are usually used often in these kinds of proceedings. Coercive control, which is really more the mental aspect, was just introduced to the restraining order law in 2024. And that really deals with the emotional abuse, controlling your partner, trying to isolate them from their friends and family, being verbally threatening, any kind of financial control. Monitoring. I had a client who put an Apple AirTag in his significant other's car so that he would always know where she was. Things like that the court will look at to determine, because that's the other aspect of abuse that the court will look at.
And here's where I want to wrap it up for today. For parents dealing with both a restraining order case and a custody dispute at the same time, what steps can help protect their parental rights while still following the court's orders?
Well, if the restraining order is issued by the district court, the number one thing you want to do is to fight to make sure that the children are not on the order. If the judge agrees and the children are not on the order, ask the judge to allow communications via email or Our Family Wizard or AppClose. Don't ask for text. Text is too easy. It's too quick. It's too easy for you to wind up getting angry and sending a message that will be a problem. You want something that requires a little bit more thought. I usually tell my clients just ask for email, because when you sit down to write an email, you have to think more, and you will potentially prevent yourself from making a mistake in the heat of a moment, which can happen much more frequently in text. You want to get into family court as soon as humanly possible. If the district court issued this, likely they're not going to give you a parenting plan. You need to get into family court so that process can get started. Don't just assume you're going to eventually work it out with the other person. Just file in family. If you don't have a parenting action already filed, your first stop after you leave district court should be the family court.
Tony, this has been really helpful and great insights for today. Thank you so much again for your time. Folks, that's it for today's episode of Law, Life, and Liberty with Anthony Puopolo. To learn more about Anthony Puopolo and his work across Massachusetts family and criminal courts, visit agplawoffices.com. Thank you for listening, and don't forget to leave a review, and subscribe to the show so you don't miss the next one. We'll see you there.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.